Hi, welcome to Pennsylvanians for Modern Courts programming on the courts and the legal system. I am Deborah Gross, PMC's CEO. I would like to thank you for being with us today. Our programs are designed to help you understand the importance of the courts, their impact on you, and their fundamental contribution to our democracy. Our goal is to provide you with resources to navigate the courts with confidence and understand your rights. After a long career in private legal practice as a litigator and as a passionate advocate for the nonprofit legal community, I pivoted to advocate for increased awareness about and access to the courts. Judicial independence is the cornerstone of our democracy, and the public's attitude towards and confidence in the judiciary has shifted in recent years. We hope these programs help you understand that judicial decisions are made based on Constitution, statutes, and the law, and not public opinion. Please visit our website, www.pmconline, that's Paul, Mary, Catherine, to learn more about PMC and find an abundance of resources on the courts. Thank you for listening, and let's begin tonight's program.
Just feel free to call me Erica. I am a record clearing attorney at Legal Aid of Southeastern Pennsylvania. So I am in the area surrounding Philly. So I know I'm coming to you from a ways away. But the good news is that the laws around what can be expunged, what can be subject to a limited access order, is completely the same statewide, and the pardon process is also completely the same. So I promise we will have some good information for you. I will also be taking questions from the chat. So if you have any questions, please feel free to put them in. Leah, I'll ask you just to read them to me whenever there's a momentary breaking point. I'll try and also pause for questions periodically. So please, the whole point of this is for this time to be helpful to you. So if you have a question, ask it, right? I have no particular desire to just hear my own voice for the next 55 minutes. So by all means, please, please, please ask your questions. I want to answer them. All right, so this is the roadmap. That's what we're going to cover today. Next slide. All right, so first things first, I think probably we're perhaps all already on the same page, but I'm going to say it anyway in case there's anyone who's not already convinced. Record clearing is vitally important. If you in Pennsylvania don't take affirmative steps, if you don't get the ball rolling by applying for a pardon or submitting paperwork for an expungement, your record will be with you forever. So these processes are the way to get rid of that record in a complete and total way. It is the way to break the cycle so that everyone can be living a full life and not hampered by something from decades or longer ago, not hampered by something that does not represent who they are, and in some cases maybe never should have happened in the first place. I am a deep, profound believer in the import of second chances and record clearing. It's just been incredible. I mean, I have former clients who are doctors and lawyers and nurses, people who are contributing tremendously to their communities and who are out earning me, and I love that. I want that for everybody. All right, next slide. Indeed, that is also true. It is not only employment and wages that are impacted, it's also education, it's also housing, it's also custody, it's also volunteer work. It really can impact almost every aspect of someone's life. Okay, so for starters, let's begin by defining our terms. I think people often will use expungement as like a catch-all. You know, I want to get rid of my record, I want an expungement. But I'm going to challenge you all because expungement is a really specific term and it means a really specific thing. So let's just make sure that we're clear on that first. If a record is expunged, it is completely destroyed. It is gone, it is shredded, it is out of the computers, it is removed from the archives. Even law enforcement no longer have access to that information if it has been ordered expunged. However, it's only available to a really narrow subset of types of records. We'll definitely talk more about what types of records can be expunged versus what ones can be sealed versus what ones can be pardoned. For now, I just want to make sure we're real clear. Expungement is destroyed, whereas some records are eligible for what's called limited access. People also call that sealing. And it all just basically means that record still exists, but it's not publicly available. That is, of course, less thorough than expungement. Expungement is the only one that results in everything getting shredded, destroyed, so no one has access to it anymore. Next slide. All right, so here we go. What is eligible to be expunged? I warned you at the beginning, right? It's a really narrow set of options. So if someone is trying to get an expungement of a misdemeanor or felony conviction, there are 3 options, only 3. And for any of our options to expunge a misdemeanor or a felony conviction, it does not matter whether it was a 3rd-degree low misdemeanor for retail theft or a 1st-degree high felony for murder. The law is the same for any misdemeanor or felony conviction. 3 options, right? Either you have to be at least 70 years old. Being 70 alone is not enough. In addition to being 70, you also have to have been off of probation, parole, no arrests, nothing at all for at least 10 years. So what I mean is, you got to wait until you're 60. You got to make sure you're off supervision, don't catch any new cases, no arrests. And then at 70, you can ask the court to expunge any misdemeanor or felony convictions. All right, so that's our first option. Most people want to get rid of their records because they want to be able to earn a decent living, maybe go back to school, get a decent place to live. And by the time we're 70, a lot of us really hope to be retired and living in our own homes. So I know this is not an option that is going to do the majority of what needs to be done. So we're going to move on. The second option is honestly the worst one. I really hate that I have to talk about it, but it's in the law and I want to be complete. So 3 years after someone passes away, their family can ask the court to expunge their record. I didn't make that up, but it's in there. The only way to be able to expunge a record for a misdemeanor or a felony conviction sooner than 3 years after one passes, or waiting to be at least 70, the only option is to get a pardon. If you get a pardon, that makes your misdemeanor or felony record eligible to be expunged. So it's a 2-stage process with the pardon. First, you get the pardon, then you do the expungement. We're definitely going to talk more about pardons in a bit, but I want to get through other things that can also be expunged. That being said, if you've got questions, put them in the chat, and I will be happy to answer them. Okay, so no misdemeanor or felonies that are convictions are gonna factor into what I'm about to say, but sometimes you get arrested, you get charged, and you beat the case. If you beat the case, the entire record is eligible to be expunged. So if those charges are withdrawn, dismissed, you're found not guilty. If the charges are null prost, which just means not prosecuted, that entire case can be expunged. There are also certain diversionary programs that aren't considered a conviction, and therefore they are also eligible to be expunged before you're 70 and without a pardon. Common diversionary programs are ARD, which stands for Accelerated Rehabilitative Disposition, but the records, they pretty much all just say ARD. You also will sometimes see what's called Section 17 probation. That's also a diversionary program specifically for someone's first drug possession case. ARD is a little bit more generic. It can be for a pretty broad variety of different types of charges. But at the time that someone is facing the charge, they have to apply for ARD. The district attorney's office has to agree to let them into ARD. And then they have to complete successfully whatever the requirements are. Sometimes there's a fine to pay. Sometimes there's community service. Usually there's a period of probation. So you've got to do all of those things. At the end of that process, the ARD case or the Section 17 case can be expunged. Now, in some counties, those expungements happen automatically, but it really does depend on the county. So Philly expunges them automatically, but Montgomery County does not. I believe that in looking briefly at the website for the court in Westmoreland, that they do not automatically expunge ARDs. So that would mean it would be, if you had an ARD in Westmoreland, you would have to be the one to file the paperwork. If you have ARD in any county, I would just encourage you to call the clerk of courts in that county and ask them. All right, besides diversionary programs and non-convictions, Pennsylvania also has summary citations. So all states have felonies. They're the most serious. We know what they are. We've heard of them before. Below that, there are misdemeanors. Pennsylvania is a little unusual in that we have a third lower category called summaries. Summary citations are things like disorderly conduct, underage drinking, public intoxication, one's first offense for retail theft. If what was allegedly stolen is less than $150, that's a summary. Simple trespass is also a summary. Harassment is often also a summary. So summary convictions can be expunged, but there is a waiting period of 5 years. You have to wait 5 years after the guilty on that summary citation. And during that 5 years, you can't have any new arrests, no new charges, nothing. Then you would be able to ask the court to expunge the summary citations. And a lot of times for folks with more serious records, we spend a lot of time cleaning things up on the front end before we submit the pardon. So the ultimate goal might be a pardon to get rid of a felony conviction. But if I have 2 cases you beat, let me expunge them first to clean things up, right? If there's a summary citation or 2 on there, let me get rid of them if I can. Anything we can do to clear up the record is going to ultimately give someone a better chance of success for a pardon. So even though it might not be one's top priority, this stuff is still really important to know. That is it for what can be expunged in Pennsylvania. That's it. Misdemeanor and felony convictions if you've had a pardon or you're over 70. Summary citations if followed by 5 years with no subsequent arrests, charges, or anything. And then non-convictions, including diversionary programs. That's it. And here we go. Generally, full expungement. So if you're expunging the entire case, do require that you not owe any money to the court on the specific case that you are trying to expunge. So if you owe money on a different case, that's fine. But most courts will enforce a requirement of having a 0 balance. That's something I would like to challenge, but for now, that is the default guidance that I have to offer, unless anyone wants to pick some really intense fights with me. Okay, if there is money still owed on your case, you can generally pay it in person at your local courthouse, or you can go online to that website and pay. If you try and pay on that website and you're unable to, that could be because your case has gone to a collection agency. If that happens, call the clerk of courts, ask them to take your case out of collections because you want to pay on it. And generally they will, and not only will they, but they'll also take it out of collections, which will save you 20%. So that is a great tip. Next slide. Oh, we already talked about this. Sorry, I got ahead of myself. We already did explain what ARD was, and that it is not always automatically expunged. Next slide. All right. So we talked about full expungements, where you beat the entire case. There's also what we call a partial expungement, where you say, okay, I I took the guilty plea to the misdemeanor simple assault, but I was initially facing charges of felony aggravated assault, felony conspiracy to aggravated assault, and felony, I don't know, reckless endangerment. All of those felony charges were withdrawn. And so I would like to have those non-conviction charges removed from my record so that only the misdemeanor that I was actually convicted of is left. I think that can do a lot of good for people, especially in this circumstance that I just kind of described, where what you pled guilty to was the least serious. I mean, I've had clients who were charged with felony attempted homicide, but ended up convicted of writing a bad check, right? I would surely not want the attempted homicide lingering on my record when it could be just writing a bad check. So a partial expungement is the way to go. It's much, much, much more likely that district attorneys object to partial expungements. So it's much more likely that you would have to have a contested hearing. And at those hearings, you are more likely to succeed if the charges that you are trying to have expunged are more serious than what is left on your record, and also if it's unrelated. So if I was convicted of aggravated assault and I'm trying to have a dismissed simple assault removed from my record, you're less likely to succeed because you've already got the more serious thing that you have on your record forever. Whereas if it's the opposite, the judge is more likely to remove the stigma of the more serious thing that you were not convicted of. So you can think about whether that's worth doing. If anyone has questions about specific cases that you're thinking about a partial expungement for, happy to hear them. One thing I do just want to flag is that because Pennsylvania automatically seals certain records, you might find that those non-conviction charges have already been sealed and are already no longer publicly available. So I would recommend, before you decide to spend the money to file the paperwork and take a day off work and go back to court and all of that, maybe look on your publicly available record to see if those charges even show up in the first place. All right. Any questions about partial expungements? Okay, so then we will talk about limited access, which I also call sealing. It all just means that record exists, but it's really only available to law enforcement. Limited access removes the record from public access, including private background checks from Checker or Higher Right or Sterling. But law enforcement still has access to it, and in some circumstances, state licensing boards also still have access to that information. It will make sure the record no longer appears on a background check done for any kind of housing. The only type of background check that it would still appear on would be an FBI background check, which is generally used for sort of those higher level jobs that have maybe a security clearance or a lot of federal regulations. You know, if you're going to work in banking or for the TSA, they're going to rely on an FBI background checks. But for a regular job, they generally don't require you to have a fingerprint FBI background check. And so your sealed record would not appear. The other thing that's really, really helpful about limited access is that once your case has been ordered sealed, if you are asked as part of a job application, if you have a record, you no longer have to disclose that sealed record in Pennsylvania. Questions about what it means to have a record be limited access or sealed? All right, next slide. All right, so here is our exhaustive list of who can still see sealed records. So law enforcement, like we talked about, and then other things that also pull from law enforcement database. So if someone applies to purchase a new firearm, have a license for concealed carry, that is going to get run through the Pennsylvania State Police system. They still have access to sealed records. They're a law enforcement, so they would still have it. USCIS, which oversees our immigration system, also a federal entity, pulls criminal record information directly from the federal system, so they still have access to it. For international travel, sealed records can also still be shared with other countries as the other countries decide whether or not to let you in. So, for example, Canada doesn't let in generally people who have convictions for DUI. So if you have a DUI that's been sealed, Canada is still going to know about it. It doesn't impact your ability to have a passport or leave the US. All of that is absolutely fine, regardless of criminal record, whether it's sealed or not. All right, in other court cases, so a custody judge could order access to sealed criminal records, for example. And then there are certain professions, such as being an attorney, where to get that credential, your sealed records will still be considered. And then, like we said, the sealed records do still appear on FBI background checks. So now I have told you all of the things that limited access won't solve for you. But if you are not in a field that regularly requires you to have your FBI fingerprints run, then sealing your record really, really will go a long way to solving the harm. Any questions about that? Otherwise, we can go to the next slide. Okay, so our clean slate law, which passed in 2019, the most recent version of it, has two different sections. One is what gets sealed automatically, meaning you don't have to have paperwork or take it to the courthouse or petition anybody or have any hearings. It just happens. And then there's another provision of what can happen, but only if you go through that process, file the paperwork, ask a judge to sign off, potentially have a hearing. So for starters, we'll just go through what happens automatically, and then we'll go through the wider universe of what can happen, but only if a petition is granted. And then we're going to talk about what might become law that would expand everything further. So under the current law, what is sealed automatically is largely non-convictions. So anything you were charged with but not convicted of should be sealed automatically. Summary convictions are also sealed after 10 years automatically. Now, remember, you can expunge them after 5. So I would rather expunge them after 5 than wait a whole 10 for it to be sealed. But if you aren't able to do anything to make it be expunged, you can at least rest assured that it'll go away on its own after 10 years. Many lower level misdemeanors are also eligible to be sealed automatically after 10 years. But it's only those low level misdemeanors. So no first degree misdemeanors, only second and third. There's also a maximum number of convictions that one can have and have any of their misdemeanors sealed. If someone has ever had a felony conviction, none of their misdemeanor convictions will be sealed. And then there are also just a specific list of things that can't or won't be sealed, which is on the next slide. Yeah, go for it. Okay, so things that will never be sealed automatically are any offenses that involve danger to a person against the family. So that would be like endangering the welfare of children, offenses involving firearms or other, items of danger. Think baseball bat. Any sexual offenses or anything that requires someone to register as a sex offender. Also, cruelty to animals or corruption of minors are never eligible to be sealed automatically. Again, this is only about what can be sealed automatically. We'll keep on going to the next slide. We'll talk about what can be sealed by asking the court with a petition. So any first, second, or third degree misdemeanor or ungraded misdemeanor can, at least potentially, get sealed by petitions. So remember, we said no first degree misdemeanors are sealed automatically, almost all of them can be sealed with a petition. Second degree misdemeanor simple assault can be sealed by petition, but it will not be sealed automatically. And one thing that's really great about sealing is that you do not have to have a zero balance on that case for it to be sealed. The only requirement is that no restitution is owed. So court debt, as you may or may not already know, comes in a lot of different varieties. The court charges money for being on probation. The court charges money to defendants to buy judges new computers. The court charges money of people with criminal cases to pay for a victim services. So there are all sorts of different fees and fines and costs. There are three main categories. The first one is fees, and that's everything I just talked about. Being on probation, the new computer fee, all of that. That's just money the court is charging because they can. Then the next category is fines, and the statutes generally say exactly what the fines have to be. So if someone has a DUI, that's a $500 fine. It's just in the law. And then the third category is restitution, which is the money to go to the alleged victim to make up for whatever harm they experienced. So if I drive drunk and I crash into my neighbor's mailbox and I mess up her yard, right? I could be made to pay the money to fix that damage. If I beat somebody up and they had hospital bills and they lost work because they were hurt, I could be made to pay that. All of that would be restitution. The restitution has to be paid or a case will not be sealed. But remember, to expunge a case, you have to have paid off everything, right? Everything completely, all of the fees, all of the fines, all of the costs, all of the restitution, all of it. Whereas for the record to be sealed, you just can't owe restitution. And I gotta tell you, in the majority of criminal records, there is no restitution that's ever owed. So this helps a lot of people who have court debt that they can never get out from under and therefore won't be able to have their record expunged. This gives them a real option. So it is a really key and important difference. Questions about that before we move on to the next slide? All right, keep going. Okay, so an individual cannot, however, take advantage of sealing even by petition if they've ever been convicted of a first-degree felony. So if they've got a first-degree felony from 1973, but they had a misdemeanor DUI from 2010, I will never be able to seal their 2010 misdemeanor because they have that first-degree felony, even though it's from decades ago. That is only about first-degree felonies. So if someone has a second-degree felony, a third-degree felony, or an ungraded felony, that is fine. That does not prevent me from sealing their misdemeanors. Then there are also certain combinations of convictions that might increase their wait time. So usually you just have to have 10 years with no new misdemeanor or felony convictions. But if you've got a couple of them, especially if it's a couple more serious ones, then you might have to wait 15 years, or if you've had 4 or more, you might have to wait up to 20 years before you'd be able to seal your cases. I know that this is very nitty-gritty. Again, if you guys have specific questions, please ask them, including just like, Erica, I'm confused, say that again. Please let me know. Okay, there are also certain categories of things that can't be sealed. So again, most misdemeanors can be sealed, but if it's specifically a first-degree misdemeanor in these categories, that can't be sealed. So for example, right, simple assault is an offense involving danger to a person. And if it's a first-degree misdemeanor, it cannot be sealed. But if it's a second-degree misdemeanor, then it can. Same thing for endangering the welfare of children. That's usually a first-degree misdemeanor, which cannot be sealed. But if it was ever a second-degree misdemeanor, it would be eligible to be sealed. Next slide. All right. So if any of you are trying to find your records and you're struggling because they are not on the state court website, UJS portal, that could be because your records have been sealed. And you might still need that information. Maybe you need to fill it out for your pardon application, right? Or maybe you're trying to join the military and they want to see a copy of it, or become an FBI agent, or any number of different things. If it is your record, you are still entitled to those records. You might have to go to the courthouse to get them because they are taken off the public access website, but you can still get them. You'll need to go and bring your ID because only you are able to get the information. So you have to be able to prove that you're you. Or you could just run an FBI background check on yourself. Either way, you'd be able to access the information. Next slide. All right. So if you are interested in submitting paperwork to ask the court to either expunge your record or seal your record, the first thing you need to know is what is on your record. You can do that through UJS portal, the state court website. You could order an FBI background check. You could go to the court and get the records. Any of them are absolutely fine. If your record will be sealed automatically through Clean Slate, then perhaps you don't need to do anything but wait until those 10 years go by. However, you might have a record that can be expunged or sealed only if a petition is needed. If a petition is needed, then you'll have to file one. Next slide. All right, so here's how you figure out whether or not you've got one. Next slide. That is the state court website, which I mentioned. And if you would a guided sort of pictograph, step-by-step process of how to search that website for your records, the guide explaining it is linked to at the bottom of the slide. Next slide. Great. Most counties require that when you submit an expungement or limited access petition, you have to include a state police background check. You should call your county clerk of courts to ask them if they will accept the e-patch background check that you get from the state police on the state police website. Most counties will accept that, and this is the process to get that. I prefer the e-patch because it comes usually in 1 to 3 weeks, which is much faster than the other more thorough version of a background check that the state police sells. So if your county clerk of courts will accept this one, use this one. All right. Then, like we said, you're going to make sure you don't owe any money on a case that you're trying to expunge, or that you don't owe any restitution on a case that you are trying to seal. If you do owe money, there's the website where you can make the payment, or you can also ask the court to waive any remaining fees or costs or fines. There are actually instructions on how to do that on the website of the ACLU of Pennsylvania. So if your income is modest, you think you're never realistically going to be able to pay off that debt, you can absolutely ask the court to waive it for you. Next slide. All right, so then once we know we have a record that can be expunged or sealed, we know we don't owe any court debt at all on the expungement or no restitution on the limited access petition, then we will file the paperwork. Next slide. All right. This just lays out the process that we did already discuss, which is that you submit the paperwork to the court at the clerk of courts. You give a copy to the district attorney's office. If they agree, it will be mailed out to you and all the right agencies. If they object, there will be a hearing. And if granted by the judge, again, it'll be mailed out to you and all of the correct agencies. Even after the expungement is granted, though, those agencies all have to physically pull your files and shred them, remove your records from their computer databases. And because of that process, I do estimate that it can take up to 9 months from filing until everything has been destroyed. Next slide. Okay, if you are wondering what the right forms are, Jenna, I told you I had you. These are the websites where you can go and download the correct forms. If all that you were ever charged with that you are trying to expunge is just a summary citation, you will use the 490 form. If you have ever been charged with a misdemeanor or a felony, then you will use the 790. This is what the forms look like. This is the petition. As you can see, it's really just one page. It's just split up into two so that we could make it all visible. But it's just one page. Most of what you are filling out is your name, your address, your date of birth, your social, all things that you know because you are you. It does ask you some basic information also about the record to be expunged, and that's why we showed you how to pull your records from the state court website, how to order that background check from the state police or from the FBI. That's where you'll go to fill out the information about the record. It also asks you to disclose what, if any, money is owed, which is why we made sure that you have zero balances before you submit your expungement paperwork and no restitution before you submit your limited access paperwork. And then it also asks for the reason why you're looking for the expungement. You can honestly write anything that you want there, right? I would like an expungement so that I can have better educational opportunities, can get into housing in a better school district for my kids, so that I can get this promotion at work, right? You could also, if you want to be like an extra big nerd, reference the expungement statute or the limited access statute, but it's really not necessary. Next slide. All right, so that was the petition. The petition is where you ask the judge to give you your expungement or to seal your record. You also have to give the judge a sample order to make it easy. So if she wants to give you what you are asking for, she just has to write granted and the date and sign her name. The sample order forms are also on that same website. It's the 790 and the 490. So that same exact website, you'll be able to get this as well. Different counties do have different additional requirements. So some of them might require you to also include a cover sheet. Generally, the clerk of courts will give that to you if they want it, or it might be posted on their website. And then, like we said, some want a particular type of background check, or proof that the case balance has been paid. And then counties do also charge a filing fee, which is why you might need a certified check or money order. You can also ask the court not to charge you that filing fee based on your income if that's a better fit for you. Next slide. All right, so for Westmoreland, all of the details for filing will be from the clerk of court's website, which is right there. If you've got a record in a different county, of course, check the clerk of courts of that specific county. There we go. I also pulled some resources for expungement or limited access assistance specific to Westmoreland. So we've got the Bar Association, which runs a lawyer referral service, as well as a pro bono office. And then there's Summit Legal Services, which provides free record clearing assistance. All right. I know you guys wanted to talk a lot about pardons, so here we go. We've got 14 minutes left. So everything that we talked about so far is very narrowly defined, right? We've got a lot of rules, a lot of how many years do you have to wait, and what do you have to have paid, and what is the right paperwork, and all of that is out the window when we talk about pardons. Anyone can apply for a pardon at any time for any record. It is completely at the discretion of the governor, and really nobody has a whole lot of ability to challenge or fight the decision. In court, right, you can appeal. Pardons are not really like that. It is much more flexible. It is also a much longer process. We talked about the worst case scenario for an expungement or limited access being that it takes about 9 months. Here, we're talking about 2 to 3 years. Honestly, I have had some clients wait as long as 4 or 5 years. However, any conviction is eligible. The Board of Pardons does strongly consider whether all of the court debt has been paid off. So I do strongly recommend that before you get to the point where the board is considering your pardon application, that you do everything you can to have a zero balance, because it makes a huge difference. They also do strongly consider how much time has gone by. So the older your record is, the more time has gone by with no new arrests or charges or anything, the better your odds of success. Now, how long we suggest that you wait really does depend a lot on the individual and what the record is for. This is where I think, a 3rd-degree misdemeanor for writing a bad check, you don't need to wait as long as compared to having, a felony conviction for something more serious. While, like I said, anyone can apply at any time, we recommend that to have a good chance of success, you consider waiting 5 years after you finished probation for a misdemeanor conviction, or 10 years after probation was completed for a felony. And I know that that can be an extremely long time, right? I know that some people are on probation for decades. And so me saying on an extra decade on top of the decades can feel extremely defeating. So take this with a grain of salt. You are all experts in your own life, and I am not at all. I don't know anything about your life. What I can say is, if it's a more serious felony, more time, a less serious felony, less time. And then the other things are really totally within your control, right? The Board of Pardons likes to see someone who is doing good things in the world, someone who has some momentum and is moving their life forward. So if you can point to community service, family and community engagement, professional aspirations, educational accomplishments, all of those things are going to be very much in your favor. And if you've got a great story to tell, then maybe you submit your application a lot sooner. Whereas someone who's been surviving, living their life and staying out of trouble, that is to be commended, absolutely. But if they don't have the other stars that the Board of Pardons is looking for, they might consider waiting more time to give themselves, a good shot. Like I said, it is completely discretionary. The process is that you submit your pardon, you wait several years, then you will be contacted by someone from state parole who will interview you. They will send you the questions in advance, so you will know what they'll be. And I'll say, anybody who wants to chime in and tell me, do you experience something different or agree with me, or, feel free to flush out this conversation. Generally get the questions ahead of time. And then the parole agent will write up a report that gets added to your file. And then the Board of Pardons, they meet for what's called merit review, where they'll consider all the application materials you submitted, plus what the parole agent wrote, and they'll vote internally. There are 5 members of the Board of Pardons. To move your application beyond merit review, you have to have at least 2 of the 5 people vote to support you. If you get less than 2 people, then your application is dismissed at that point. You can always reapply, but first you can ask for reconsideration, and then if you are still denied, you can reapply, but there's a wait time. I honestly don't remember this moment if it's 1 or 2 years, but it's not 30 years. It's a smaller amount of time, no more than 2. If you get at least your 2 votes at the merit review, then you will be scheduled for a full hearing before the Board of Pardons. Before COVID, those hearings were happening in person in Harrisburg in the Supreme Court chamber. since COVID and continuing now, they've been happening via Zoom. I hope and anticipate they will continue to happen via Zoom, but I really don't know. It's fully possible that someone who submits a pardon now might be required to travel to Harrisburg for their hearing in 3 years. At that hearing, each of the 5 members will be able to ask questions. We recommend strongly that people review their pardon application before the hearing so they remember everything that they wrote. And then also be ready to update the Board of Pardons with anything new that's been going on, right? You have a new child, you get your associate's degree, you move, you get a promotion, you know, you want to be ready to provide those updates and ready to answer any questions. The Board of Pardons really likes to see someone who can demonstrate insight into what they experienced and why they experienced it, right? So, you know, my pardon applications for my clients, they almost always begin at childhood. What were you experiencing at that point? How did it contribute to who you were at the time of the record? And then who are you now? So we're really telling a very person-centered story. It's really very holistic. All right, if the Board of Pardons, if at least 3 of them vote to support your pardon after your hearing, then it is recommended to the governor. And even after all of that, the governor can still do whatever he wants. He is not bound to follow what the Board of Pardons recommends, although thankfully, he often does follow their recommendation. There's also no timeline for when the governor has to act on the recommendations. It could be a day or 10 years. If your pardon is granted, you will receive a pardon decree in the mail. It is beautiful. It has the governor's signature and a raised golden seal, and it fills me with excitement. And yet, it is just a piece of paper, because your record will still exist if you don't then follow up with step 2 of getting your expungement. That is what gets it completely wiped away. Lest anyone think that they might go through all of this to get a pardon and then be denied the expungement, let me put your mind at ease that there is a Pennsylvania Supreme Court case that says once that pardon is granted, as long as it is a full and unconditional pardon, your expungement shall be granted. So the judge is not even really allowed to say no to you. All right, next slide. All right, if you would like to apply for a pardon, you can download the application yourself for free at the website right there. And if you look at that and you are overwhelmed, intimidated, freaked out, let me encourage you not to give up, but to go look at the pardon information packet, the second link on that slide. Myself and my colleagues, we made that to help folks navigate this process. So read that before you give up, because it might make it a little bit more accessible.